Now. Welcome to ALRP Spring MCLE series. This is session number 4, an introduction to VA disability benefits presented by John Unruh, one of our esteemed board members. Just next slide, please. So the agenda for today is we'll give a brief overview of ALRP and the panel, and then we'll conduct our substantive training, and we'll have our question and answer session after the training, followed by a brief reminder to fill out the evaluation and the wrap up. Next slide, please. Just a little housekeeping, just so everybody knows, the training is being recorded and all participants are muted. You may enter questions in the question and answer function, which is down at the bottom there, and we will address them in order after the presentation. We usually have about 10-15 minutes for questions. I will send a link for the evaluation right before we end the session along with the slides. Please fill out the evaluation. You need to do that in order to receive the MCLE credit. It will be probably a couple days, 2-3 days, because I have to run through all the evaluations manually and all. It takes a little bit of time. And if you don't receive the slides or the link, within an hour after the presentation, please send me an email. There may have been an error in transcribing your email address or something like that from the sign-up sheet. Next slide, please. So ALRP's mission is to advance and protect the rights, dignity, and health of people living with HIV/AIDS in the Bay Area. Currently, we have had for 2024, that is, over 2,000 legal matters handled and nearly 1,300 unique clients assisted. We have around 140 active members of the panel, and it's not nearly enough. As you can see, that is a huge amount of people that need help. Next slide, please. So we rely on our panel attorneys to provide low-cost legal counseling and representation on civil legal matters, and we tailor the experience of our panel attorneys to their practice areas. We don't ask much for panel attorneys. Some are doing enormous amounts of work for clients, but all we ask is that panel attorneys accept 2 referrals, just referrals a year. And there's always the option to accept or deny the referral after we contact you. Panel attorneys, of course, receive free MCLE trainings like this one. Mentoring, we're really picking up our mentoring program this year, as well as malpractice insurance and access to legal resources through us and many of our partner organizations, of which there are dozens around the Bay Area we are working closely with. Next slide, please. So if you're interested in joining our panel, and now more than ever, we need attorneys that can help. With the Trump administration coming in particular, there has been a tidal wave of clients who need help on immigration matters. I'm not even kidding. We went through the numbers last night. We're talking about 150% increase in the number of clients coming to us with needing help with immigration matters. So if you want to join the panel or volunteer on legal matters, please contact me there or the link right there. Next slide, please. If you are unable to volunteer for the panel and you'd like to support us in other ways, like money, for example, is always helpful, please go to the ALRP website and hit the donate link or contact Sloka, who's absolutely wonderful, and he'll talk to you about options. Next slide, please. And we would like to invite you to ALRP's 42nd annual reception, which is on October 23rd at the Grand. We are pleased to announce that this year we're honoring Hollywood legend and icon George Takei. This is a fantastic opportunity to meet a man who is not only known to millions over the past 6 decades as Captain Sulu of the Enterprise and then the USS Excelsior, but who's also been an LGBT icon and activist, as well as an activist for Japanese Americans who were interned during World War II without due process. Kind of timely, once again, always demonstrates that people tend to forget over time as history fades. So please buy a ticket. The link is listed there, and there's also a link on ALRP's website. Don't miss out on a chance to meet George. He's amazing. So you can hear him say, "Oh my." Now, we're pleased to present John Unruh, who's our esteemed board member who has been helping people with VA benefits for a long time. And I have to say, as a veteran myself, it's incredibly helpful because when we get out of the Army or the Navy, Air Force, Marines, they really don't tell us anything. And it's through help with attorneys like John that we were able to get benefits that we earned through our broken limbs and other things like that. It's also part of a larger push by ALRP that we're focusing heavily on SSI benefits and other benefits as the system is changing under the tender auspices of Elon Musk's Doge and taking a hatchet to everything else. People need to know where they stand and if there are changes, how they need to make sure that their benefits don't stop. So I'll shut up now and please, John, take it away.
Thanks, Jake. Good afternoon, everyone. Thanks for joining us today. I just would like to reiterate or do another push for the panel attorney program that ALRP has. I've been on the panel for over a decade, and it's a really great way to give back to the community, to learn about potentially a new practice area, and help clients in need. And ALRP, as Jake said, provides resources to the panel attorneys if you ever need help with one that you take on. So a big push for the panel attorney program. Okay, so my name is John Unruh. I have my own law firm here in the city, Unruh Law. We specialize in VA disability benefits. I have been practicing in this area since 2007. In 2007, I was hired by Swords to Plowshares, which is a local veteran service organization here in San Francisco that some of you may be familiar with. I worked there as a staff attorney for approximately 7 years. And then I went solo around what year was that? 2013, 2014? It's hard to remember. And I've been a solo for the past decade doing VA disability benefits work. It's a very rewarding practice area, but also it can be rather complicated. So today we're going to go over some basics, and I will give you a big overview of the process. And then at the end, I will go through some sample decisions issued by the VA, and then also go over some of the claim forms that are used by the VA to adjudicate these decisions. So what is the Department of Veterans Affairs? It is a department of the federal government, but it's kind of broken down into 3 different sub-departments. There's the Veterans Health Administration, the Veterans Benefits Administration, and then the National Cemetery Administration. The Veterans Health Administration is the organization that oversees all of the VA medical centers and the VA clinics that are throughout the country, such as Fort Miley, which is out here out on Geary Boulevard here in the city. And there's also a clinic off of, I believe that's Bryant Street over here in Soma. So they are the single payer healthcare provider for veterans. We will not be really discussing that today. The National Cemetery Administration is the organization that oversees all the national cemeteries and helps with burial reimbursements for veterans and their families. We also will not really be discussing that part of the organization today. Today, we will be focused almost exclusively on the Veterans Benefits Administration, which is the part of the VA that oversees the adjudication and distribution of benefits to veterans and their families. So what are VA benefits? There are multiple types of VA benefits. Some you've probably heard of, some you probably haven't. There is a VA pension, which is not service-connected. What service-connected means, we'll talk about in a few minutes. It is means tested, meaning you have to be low income in order to be eligible for the VA pension. There is a VA service-connected disability compensation, which is to compensate veterans for conditions that are quote unquote service connected, which we'll talk about in a little bit. And this benefit is not means tested, meaning you could earn any income or be worth any amount of money and still be entitled to service connected disability compensation if you meet the criteria that we'll be talking about today. Some additional benefits are benefits for dependents. DIC and survivor's pension are benefits available to widows. VA healthcare, which again, we're not going to be talking about much, but that's another benefit administered by the VA. Education and training. I'm sure many of you have heard of the GI Bill. That's a benefit administered by the VA. There's the home loan program, which again, I'm sure many of you have heard about or are familiar with. There's also life insurance and burial and memorial services. Today, we are going to be almost exclusively dealing with disability compensation, because that's really the area where attorneys can really have the most impact. And it's also really the only area where, if you're going to be doing this for a fee, where attorneys can accept a fee for their services. So let's start with the basics. What is a veteran? In order to qualify as a veteran, you have to have served in one of the federal branches, such as Army, Navy, Air Force, Marines, Coast Guard. There's also now the Space Force. Since these slides have been drafted, I guess I haven't updated them with that new branch. National Guard, if you're in a state National Guard, you qualify for veteran status if you've been activated on a federal basis. If you are a reservist, you qualify if you've been mobilized on active service. And in order to also be a veteran, you must have honorable service, which means a person who has served in the active military, naval, or air service who was discharged under conditions other than dishonorable. This is defined in the negative, so that can be a little bit confusing, but it's essentially anyone with an honorable or general discharge, which we'll talk about a little bit more in a few minutes. And in order to be a veteran, you must not have a statutory bar to the definition of veteran, which means you cannot have been discharged for being a conscientious objector or a deserter or going AWOL greater than 180 days. You're generally not going to see any of those, but it's just something to be aware of, because in order to be eligible for VA disability benefits and the disability compensation, you must meet the threshold eligibility of what is a veteran. If for some reason you encounter a client or a veteran has a less than honorable discharge, there is a way through the military branch that you can challenge the discharge status, but we're not going to be talking about that today. The VA has its own way to reevaluate a less than honorable discharge, and it's called the VA character of discharge evaluation. So again, the different characterizations of service are honorable, general, other than honorable, bad conduct, dishonorable, or uncharacterized. Uncharacterized is usually if someone's been in the service for maybe only a few days or a few weeks and they're separated due to not being a good fit. Most of the veterans that you would see are going to have an honorable or general discharge, or potentially an other than honorable discharge. Other than honorable discharges are usually given if there's been behavioral issues or substance issues. Through the VA, someone with an OTH is not going to be eligible for VA disability benefits. They might be eligible for healthcare or a service-connected condition, but they're not going to be eligible for any monetary benefits such as compensation or educational benefits. However, if the circumstances surrounding their other than honorable discharge is related to, let's say, a psychiatric condition that is related to service, and the disciplinary issues that led to the OTH involve substance abuse because they were self-medicating due to their psychiatric condition, something along those fact patterns could lead the VA to grant a favorable character of discharge determination. meaning in that instance, the underlying other than honorable discharge would not be changed for purposes of the military, but for VA purposes, they would otherwise be eligible for services through a favorable character of discharge evaluation. This is a very complicated process. It requires a lot of evidence to support in the terms along the lines of medical opinions and character evidence. So we're not going to go too much into that today, but it is something to be aware that even if you are working with a veteran with an OTH and other than honorable discharge, there may be an avenue through the VA in order to qualify them for VA benefits. Okay, we're briefly going to talk about pension. Again, this is not what we're going to be spending the majority of our time on. Many veterans qualify for. For this benefit, you must meet the veteran definition that we talked about a few moments ago. And this one has a time in service requirement. Before 1980, a veteran must have served at least 90 days. Since September 1980, the time has increased. It must be at least 24 continuous months or completion of a time ordered to active duty or a compensable service-connected disability. And we'll talk about that in a few minutes. In order to qualify for the pension, you also must be disabled, which means permanently disabled for any reason. If a veteran qualifies for SSI, that's usually sufficient. Or a veteran must be 65 years old or older. The real qualifying condition here, though, is you must be low income. This is some old information here in terms of the rate, but as of back in 2021, your monthly income must be under about $1,600, and you must have assets under 138,489. Those numbers have probably increased a little bit over the past 3 years, but still they're going to be quite low. You must be of minimal means. Otherwise, you're ineligible for pension. You must also have wartime service, and that means at least one day during a declared wartime period. The declared wartime periods for VA purposes are listed here. Most of the World War II veterans are unfortunately no longer with us, but there's still a handful of Korean and, of course, Vietnam and Persian Gulf War era veterans. The thing to note here is, according to VA purposes, we have been at a continuous time of war since August 2nd, 1990, which is quite incredible. But if you encounter a veteran that is outside any of these quote unquote wartime periods, they are ineligible for pension. Similarly, if they don't meet the means test, they are ineligible for VA pension. If any of you do Social Security work, this is very similar to SSI, where there is a means test. Someone has to be quite low income in order to be eligible, and they have to be permanently disabled, meaning they're unable to hold any job, any gainful employment in the national economy. However, if you do work with that population and they are eligible for SSI, the one thing to keep in note is if you do encounter a veteran on SSI, you should check to see if they're eligible for pension, because the pension benefit is typically greater than the SSI benefit. So just something to bear in mind. Okay, now we're going to talk about service-connected disability compensation, probably for the remainder of our time today. This is definitely the greater benefit and the one that I spend really every day working on. And if you get into this practice area, it's likely what you will be focusing on as well. So the VA service-connected disability compensation system is designed to compensate veterans reduction in earning capacity caused by their military service. It's awarded on a percentage basis from 0% to 100% in 10% increments. And note that not each disability is rateable at each increment. It leads to a monthly payment, and the payments are tax-free. So to be eligible, you must meet that veteran status. There's no time in service requirement. You can be in boot camp for 1 day, be injured, and be eligible for compensation. The service connection. I know I've mentioned this a few times, and here's the definition. There must be a current disability that's incurred or aggravated during service. That is started in the service or was aggravated by service, and is carried forward to the time of application in the present. And then there must be a rating, an evaluation of a present impairment. So to have a viable claim for service-connected disability compensation, you need these three elements. You need an in-service event, injury, or diagnosis, plus a current disease or disability, and a nexus between the two. So we're going to spend the next few minutes unpacking what these three elements mean and how you can substantiate a claim for service-connected disability compensation. So you need, again, a current diagnosis. The majority of my cases involve some type of mental health condition. And for a diagnosis to be compliant, or for a mental health diagnosis for VA purposes, it needs to be a diagnosis consistent with the DSM-5, which some of you may be familiar with. It's the Diagnostic Statistical Manual, the 5th edition, put out by the American Psychiatric group. I think I forget exactly who, but it's basically the tool that mental health professionals, at least in America, use to diagnose individuals. And then just note that a quote unquote personality disorder is not going to be something that's compensable by the VA or service connected, or able to be service connected. But the caveat there is oftentimes the military will dismiss individuals who are experiencing a psychiatric issue and dismiss them from the service as having a personality disorder. So you'll often find veterans who have personality disorder written on their separation papers or in their service medical records, when really you're dealing with a psychiatric condition that wasn't diagnosed. So just be aware of that if you ever see that in a claims file. So the diagnosis and the condition must have been incurred or aggravated during military service. And this can be shown by lay evidence of an event or symptoms commencing. There can be medical evidence in the form of service treatment records during the time in service. Some conditions, if they become evident or symptomatic after discharge, but within a certain amount of time, they can be service connected if they're one of the certain conditions that must manifest within what's called the presumptive period. One of the more common ones is for some of the neurological conditions, such as multiple sclerosis. If symptoms appear within a certain time frame post-discharge, the VA is going to assume that it began within the service. There's also a concept called the presumption of soundness, meaning unless there's clear and unmistakable evidence of a condition pre-existing the service, the veteran is presumed to have been of sound health upon entry into the service. And another facet of the condition or the diagnosis is it's not a result of willful misconduct. So an example of that would be if a veteran was severely injured in a vehicle accident during service, but the vehicle accident was caused by them driving under the influence of alcohol or drugs. That would be an incident of where a veteran was injured in the service, but because of their willful misconduct, it's not going to be eligible for service connection. Another important thing to point out here is, the injury has to have incurred or aggravated during military service. It does not need to have been incurred or aggravated due to a service member performing duties related to their military occupation. So in that other example, or the example with the car accident, if someone had been driving, home to see family and friends for the holidays, but still on active duty and got into an accident through no fault of their own, that would be eligible for service connection. If someone was on a vacation during active duty and they were playing, basketball with friends and they injure their knee or elbow, that too could be service connected. It does not need to be in the performance of any military specific duties that the injury or condition is incurred or aggravated. Okay, so these are the different rates that one can be rated and the corresponding monthly amount. As I mentioned a few slides ago, this system is meant to compensate a veteran for their perceived occupational impairment due to their service-connected condition, and it goes up in 10% increments. So someone who is presumed to be 10%, or someone who is 10% service-connected, under this system, the idea is that they remain 90% not impaired. And so the 10% disability equals $175.51 per month. As the increments go up, the money goes up as well. And a big thing to note here is even at 90%, it's a pretty good amount per month, $2,297.96. They're still assumed to be 10% able-bodied, 10% able to pursue a gainful employment. So that's why there's a huge jump between 90% and 100% when one is presumed to be unemployable and unable to engage in any gainful employment. That amount jumps up to $3,831.30. So it's quite a big difference between 90% and 100%. Okay, so back to this slide. Remember, there needs to be an in-service or injury, a current disease or disability, and a nexus between the two. So what is a nexus? It can be a casual relationship between the in-service injury and the present disability. And there are multiple theories of service connection or what we call a nexus. There can be direct, which typically requires continuity of treatment. In terms of physical injuries, this is often self-evident. If someone severely injures their leg or their arm, or if there's even an amputation in service, it's going to be pretty self-evident that regardless of how much time passes from service to an attempted application for benefits, that it's the same underlying condition. The condition must be chronic, meaning it's not a transient condition. Therefore, if someone, if someone is treated for a respiratory condition in service, and then 20 years later files an application for COPD, there could be issues getting that service connected. Was the respiratory condition in service an early symptom of what eventually led to be COPD, or was that a transient just bronchial infection that eventually resolved itself and totally separate from the later diagnosis of COPD 20 years ago? So in order for there to be a direct service connection, it must also be chronic. That does not necessarily mean a continuity of treatment, though. Certainly, there are some chronic conditions, such as, like I said, MS or some other neurological conditions that might manifest themselves in service, but there could be gaps in treatment for a variety of reasons. There's also what are known as presumptive conditions, where no quote-unquote nexus is required, and these are set by statute. Some that you might be most familiar with is during the Vietnam era. As I'm sure you know, the US military used a lot of defoliants and other herbicidal toxins to destroy a lot of vegetation in Vietnam in an effort to make the Vietnamese quote unquote enemy more visible. And this has led to a whole host of health issues, both for the Vietnamese and the service members who served in Vietnam. So some of the presumptive conditions that have been linked to those toxins, such as Agent Orange, are diabetes and hypertension. So if a veteran served in Vietnam and can show that they served in Vietnam with their quote unquote boots on the ground, they can file an application for diabetes or hypertension, or now Parkinson's, prostate cancer is another one. And they need to do nothing more than show that they were in Vietnam. They're presumed to have been exposed to Agent Orange, and those conditions that I just named are presumed to be a result of their service. Recently, some of you may have read about the passage of the PACT Act, which was a law that was passed by Congress a few years ago and signed into law by then President Biden. The PACT Act kind of expanded upon the Agent Orange presumptions and really is an attempt to address the toxic exposure that the more recent veterans have experienced as a result of burn pits and other types of toxins in the air through service in Afghanistan and Iraq. Really, some unexplained illnesses, different types of cancers. And similarly, as with Agent Orange, if a veteran can show that they served in Afghanistan or during in Iraq, in a certain location in the Middle East, and were exposed to some of those toxins, then there's a whole list of conditions that are presumed to be the result of that service, and they don't need to show any continuity of treatment or anything like that. So in addition to direct service connection, there is secondary service connection. And this is a condition that is a result of another condition that is already service connected. So this could be if you have a leg injury that's service connected, you may over time develop a secondary hip condition as a result of having to compensate your walking or your mobility. That would be one example. Another could be if you have hearing loss that's service connected and your hearing loss causes you to be depressed because you feel that you're left out of conversations with your family and it's hard for you to socialize. Depression could be a secondary condition to hearing loss. Similarly, if a client has depression and they self-medicate with alcohol and they develop cirrhosis of the liver because of that, a liver condition could be secondary to a mental health condition by way of an alcohol issue. So secondary service conditions are a way where, and this is where clever lawyering can really come into play, because you want to look at your client and all the conditions, medical issues that they're having. And the service records may say one thing, and they may think that only certain conditions are related to their time in the service. But then you start asking some questions, such as, does your hearing loss, like I just said, cause you to feel shut out from conversations, unable to engage in social activities, etc.? And that may lead to a mental health diagnosis on a secondary basis, and that would lead then to more benefits. So just something to think about when you're dealing with clients. 1151 is another type of service connection, and this is where someone receives medical care from the VA that the VA then concedes was negligent. An 1151 claim is basically a tort claim against the VA. The VA compensates the veteran due to the negligent care, but it's not service connected. In this case, it's connected to negligent care by a VA medical provider. You probably won't see too many of those, and I don't either in my practice. So there must be competent evidence to lead service connection, and this must be a medical opinion. You can also use treatise evidence. but that's not often given much weight. When you fill out an application for disability compensation, a veteran will be scheduled typically for an exam with the VA medical provider, but it's best practice to really get your own medical evidence in there because the medical opinions provided by the VA aren't always great. And so you want to put together the best sort of package you can for your client, and that usually requires getting a medical opinion of your own. One thing very unique about this area is the standard that is used. Typically, in most contexts in the law, the standard is a preponderance of the evidence. Here in VA disability world, it is at least as likely as not. So 50% or greater. The benefit of the doubt is always going to go in favor of the veteran. So that's very helpful as advocates. And if you're working with medical providers, it's good to remind them of that the medical provider does not have to say with any degree of specificity or certainty that a condition is related to their service. They just have to say it is at least as likely as not, or 50-50. So the compensation rates, as we talked about, go from 0% to 100%. And there's a whole schedule of disability in the Code of Federal Regulations. And under all the conditions that the VA would rate for, there's different percentages assigned based on the severity of the condition, which correlates in this context to the measure of functional loss in earning capacity. Again, it cannot be a temporary or permanent. It cannot be temporary. It can only be a permanent condition. If it is a situation where someone's getting surgery and then there's a period of time in which they need to recuperate, there could be a temporary permanent condition, but then the VA would always come back and rate them on the permanent residuals of that type of surgery. Combined ratings, this can be quite confusing for the clients. So say someone is rated 10% for ringing in the ears, and they're rated, let's say, 30% for a mental health condition. That adds up to 37%, which is increased to 40%. And how I got there was you take the highest rating. In my example just now, that was 30%. So that means that leaves 70% able-bodied person, and then you apply the next highest disability rating to that percentage. So 10% to the 70% would be 7, and that's how I got 37%, which leads to 40%. That example is probably not too confusing because a 10 and 30 do equal 40%, which is the combined rating that you end up with. Where it can get confusing is when you get into a situation where, say, someone has 70% for a mental health condition and then 50% for, let's say, a migraine condition. So 70% is the first condition, the highest rating. Then you take the 30% able-bodied remaining part, apply 50% to that. 50% of 30 is 15. And you add that to the 70, which is 85%, which is rounded up to 90%. But it doesn't equal 100. So you'll get a client saying, I should be rated 120%. I have a 70% rating and a 50% rating. But that's not how it works. You have to sort of rank the ratings in a descending order and then apply each lower rating to the remaining able-bodied percentage that you get. I know that's confusing to a lot of you. Luckily, there are calculators that can do this for you. But if you do work with these clients, just know that you're going to be getting that question if you have a client who is rated for multiple conditions. They're going to come to you and talk about how they're rated 300%, but that's not possible. And a good sort of way to explain this is if you've ever been shopping on Black Friday or something like that, and let's say just to use that example I just used, there's a shirt that's 70% off that you want, but a Black Friday doorbuster sale is an extra 70% off. That doesn't mean that it's 127% off and you get the shirt for free. It means that they add the 50% off on top of the 70%, which means it ends up being 85% off. Again, there's calculators online. Don't worry about it. But if you can't do the math in your head, but just know that that's an issue that comes up a lot with clients. No pyramiding means that a veteran can't be compensated for the same symptoms twice. So some conditions, lead to various types of symptoms. Physical conditions are a good example where there might be some mobility issues with someone's arm, and there's also some neurological nerve issues such as radiculopathy that might present itself too. Sometimes the symptoms might be better in one issue versus the other. Just know that symptoms can't be counted twice in under the rating schedule. Another thing that's important to know is there is this benefit called a total disability for individual unemployability, or TDIU, as may be evident from the examples I just gave about combining the ratings. It can be quite challenging to get to a total 100% rating, even if one's rated for many different things. But so TDIU is a way that if someone is rated 60% for a condition or multiple conditions that are 70% or higher, and they're unable to work due to one or multiple service-connected conditions, they can then get what's called TDIU, or individual unemployability. And if they can show that, they then are paid at the 100% rate, even though they're not rated 100%. And as this slide shows, there's a big difference between 70% and the 100% rating, almost twice the amount of money every month. So this is a great thing to look for when if you're potentially going to take on clients. Someone might be 80% and wanting to file additional claims to try to get to 100%. But it may be best to not file additional claims, just work with the claims and the ratings that they have. And especially if they're unable to work because of any of them, and just go the IU route, because it will get them to the same place, which is getting paid at the 100% rate. And all you'll need to do really is get a vocational expert or a medical professional to confirm that their condition that's service connected prevents them from being gainfully employed, which currently would be about $1,200 a month or more. So someone could still be marginally employed, earning under that, and qualify for IU. Just know that IU it's not means tested per se, but someone cannot be earning more than marginal. Someone cannot be marginally employed, earning more than $1,200 a month and receiving IU. So just be aware of that. Okay, so these are some benefits for dependents. There's DIC, which I mentioned before, which is dependency and indemnity compensation. This is a benefit that's paid to survivors. So if a veteran was receiving some service-connected compensation during service, or during their lifetime, or if they passed away due to what later posthumously is considered to be a service-connected condition, the widow can receive what's called DIC. It's not a substantial amount of money. It's about $1,500 a month, but it is something eligible for a survivor. Survivor's pension. This is means tested. You're probably not going to see too much of that, but it is a benefit for low-income surviving spouses. And just note in this context, survivors, I'm using widow because that's typically the only eligible survivor. In order to be eligible or meet the definition of survivor, you have to be a widow or a minor child or an adult dependent child. And typically in this population, when the veteran passes away, if there are children, they're no longer considered survivors for VA purposes. because they would have aged out of that definition. Okay, so how do you file a claim? To file a claim, a veteran would have to initially file what would be called an original claim. This would be the first time that they're filing a claim for that condition. That is done on a VA form 21526. VA, as with most federal practice areas, is very form driven, and the VA has a form for almost anything. And you have to file it on the correct form or it'll be rejected by the VA. So to file the claim for the first time, you must use the 21526. If the claim then is eventually granted, or even if it's denied, and you want to later appeal that, you would then use a supplemental form. And I'll have some examples of this at the end. A supplemental claim form requires new and relevant evidence, but please note that that is an extremely, extremely low bar, and pretty much anything would qualify for new or relevant evidence. I'm not going to get into Q too much, but just know that there is a way to overturn a previously adjudicated decision if there's clear and unmistakable error. That's a very high bar, and it's extremely rare. So you file an initial claim for benefits or a supplemental claim for something that had been previously adjudicated. And again, it must be on the proper form. And then the VA will undergo a development process where they send out notices to the veteran and the representative, if there is one, asking for additional evidence to help substantiate the claim. Once that's done, if the VA believes there is enough to proceed, they will schedule the veteran for what's called a compensation and pension exam. This is where the veteran will go in before a medical professional that's hired by the VA to do an evaluation of the veteran. And then that medical provider will write up an opinion. If it's a claim that's not service-connected, they will form a nexus opinion and opine on whether or not they believe the condition is related to the service or not. If it's already a service-connected condition and you're seeking an increased rating, they will just look at the severity of the condition and whether or not an increased rating is warranted. The big thing to note here, though, is the C&P examiners, even though they've been trained presumably on VA exams or VA disability compensation and what's needed, they often don't have a great grasp on the process. And you'll often see examiners, especially in the nexus context, using the wrong standard. As we talked about a few minutes ago, the standard here is at least as likely as not. And you'll often see C&P examiners forming a negative nexus opinion, saying things along the lines of, there's not enough evidence to support that this is related to service. I cannot conclusively say this is related to service. That's the wrong standard. You could easily get that overturned on appeal, but appeals in this context, as we're going to talk about soon, so that's all the more reason why, which I mentioned, I believe at the beginning, you really want to be submitting these opinions with your own medical evidence to support a nexus. So after that's done, a rating decision comes out, and the rating decision will either grant service connection. If they do, then they'll assign a percentage and an effective date. And those are all issues that are ripe for appeal. After a decision is issued, you have 3 different ways to handle a disagreement with that decision. And I will talk about, or I'll show you some examples of these forms in a little bit. You can do what's called a higher level of review. That's where you cannot submit any new evidence, but presumably a more well-trained VA employee will take a second look at the decision and see if a higher rating or some other type of alternative decision is warranted. You can submit a supplemental claim, And again, that would require new and relevant evidence, but the bar on that is quite low. Or you could appeal it to the board. And the Board of Appeals for Veterans Claim is a level of review within the VA that's outside of the regional office level. So this arrow here, this first arrow, is all within the, the regional office, which is the lower level of adjudication. Above that is the Board for Veterans Appeals. If you take somebody to the board, you are going to be before an ALJ. You have a 1-year deadline to appeal to the board. At the board, you can either appeal something into direct review, meaning you can submit no more evidence. You can appeal into the evidence submission lane, where you would have 90 days to submit additional evidence, or you could submit it into the hearing lane, where you would request a hearing in front of an ALJ. The BVA hearings can be in person, but they're typically via Zoom, especially in this post-COVID world. Just note that the board decisions typically come with a remand back to the regional office. In terms of current wait times, the regional office appeals typically take between 90 days, meaning if you file a higher level review or supplemental claim on a decision, you're going to get a decision within 90 days or so. At the board, decisions are typically taking 3 years. Yes, 3 years. So you want to be very judicious with what you take up to the board, given the amount of time that's involved. One thing to note, though, is if a veteran is 75 years old or older, they are eligible for advancement on the docket at the board, which means a decision typically within 90 days. So currently, I have instructions to my staff that I don't really want to see anything going to the board unless the client is 75 or older. If they are not that age, I really want them trying to get a favorable decision out of the regional office. The only time we really take things to the board for a client that's under the age of 75 is if it's a technical legal argument that I just don't think the staff at the regional office is able to handle, and we really need an ALJ and people with more legal training to understand what we're getting at. After the board, if you receive an unfavorable decision, you can appeal it outside of the VA to the Court of Appeals for Veterans Claims, which is a court that's set up in DC to only handle claims or appeals from the board. It is not part of the VA, and again, it's a special court that only handles veterans claims. After that, if you get an unfavorable decision from the Court of Appeals for Veterans Claims, you can appeal to the Federal Circuit, and from the Federal Circuit, you would go to the Supreme Court of the United States. So that's a brief overview of the claims process. But again, these decisions and times are measured in years. And if you're up at the board or up at the court, you're typically dealing with claims and appeals that have been pending for 3, sometimes 5, sometimes even longer. I currently have a case up at the court that I have been continuously pursuing since 2011, so 14 years. It's kind of an outlier, but it happens, unfortunately, for my client. But I think we're finally going to get a good decision after many, many remands. Okay. Briefly, there's many different VA housing assistance programs. Probably the one you've heard of the most is going to be the VA loan program. There's also HUD-VASH for homeless or homeless veterans or veterans that are at risk for homelessness. This is similar to a Section 8 voucher. And then there's for veterans that are disabled and need to make certain ADA adaptations or, such as wheelchair ramps or modified bathrooms due to their service-connected conditions. A veteran can apply to the VA for assistance to pay for contractors to make modifications to their home to make it friendly to for their mobility needs. Okay, So now if you are an attorney and want to get into this area, you can charge fees, but it's heavily, heavily regulated. So let's just go over briefly how you can receive payment for representing veterans in this context. So first of all, you must be accredited by the VA. If you have any interest in getting into this area of the law, I would recommend that you apply for accreditation as soon as possible. Because as with the claims process that we just talked about, the VA accreditation process can take months and even years, and you're not able to charge a fee or help a veteran until you're approved. So get that application in now if that's something you're interested in. So fees are allowed, but there are limitations. You cannot charge a fee on an initial claim, an original claim, but you can charge a fee on any subsequent filing. A 20% contingency fee is presumed to be reasonable, and a fee agreement outlining a 20% fee can be filed with the VA, and the VA will withhold that fee from any retroactive award that is given to the client as a result of your advocacy. So let's say a veteran has been denied for PTSD, and you agree to file a supplemental claim for them. You submit, along with your 20% contingency fee withholding agreement, you submit a supplemental claim with new and relevant evidence. And within 1 year, they are granted 100% rating at, let's just say for easy math purposes, that with their dependents, that ends up to be $4,000 a month back for 12 years. So that would be, or not 12 years, 12 months for 1 year. So that would be 12 months, do some math right now, 12 months at 4,000. So the retro would be 48,000. The VA would withhold $9,600 for you for your payment. You would not be entitled to any amount of their ongoing benefits. You could only receive a fee off of a retroactive award based on your advocacy. And then the VA would withhold that again if your contingency fee agreement is 20%. You can charge up to 33.33 or 1/3%, and still that's presumed to be reasonable. But any amount charged to the veteran over 20%, you have to collect the fee from the client yourself, which of course carries some risk. So in that example I just gave, if the client received a retro benefit of $48,000, but you're on a 1/3 fee agreement, you could potentially collect up to $15,998, but you would have to collect that directly from the client. Burial benefits. We're not going to go too much into this, but just know that the VA does pay burial allowances to veterans and reimbursements for burial expenses. That's kind of a separate process under the sort of the three departments that we talked about at the very beginning. There's more information here at that link. And then again, there's miscellaneous benefits, clothing allowances. You can get a potential additional monetary benefit amount for caregivers if your service-connected conditions mean you need assistance of a third party. And there's some various life insurance policies. Here's some more information about the burial benefits that are one's eligible for, and some educational benefits. And then VA healthcare. This talks briefly about that, and that link there, it may not be valid anymore, but there's a lot of information on the VA website about the different types of healthcare benefits. And typically, a veteran who was service-connected for a condition is going to be eligible to receive healthcare from the VA for that condition at no additional cost. Okay, now real briefly, before we get into questions, I am going to go through some examples of the forms that are used that we talked about and show you some examples of what a VA decision looks like. So can everyone see the slide? Is this coming up, Jake?
Yes.
Okay. So let's first look at the sample of a rating decision. So even though this is back from 2019, almost 6 years ago, the VA decisions still look very similar. So they have the date that the VA decision was decided. We talk about how a decision's been made on VA benefits. And here in this bullet, they talk about what the decision is. This individual's claim for service connection for post-traumatic stress disorder has been denied. And they're saying because the evidence submitted is not new and relevant. As we talked about, that standard is extremely, extremely low. So unless this veteran submitted absolutely nothing, that's going to be something that you can challenge in an appeal. As with Social Security, for those of you who do that practice area, unfortunately, when you work in this area, you got to prepare yourself and, more importantly, the client that when you submit an application, you got to expect a denial. The VA just loves to deny claims, especially initial claims, or they grant the claims, but they assign a rating that's too low or the wrong effective date. So what else does this rating decision tell us? Even though PTSD was denied, this veteran is receiving something else as of 2014. So they must be receiving, they must be service connected for something. I don't know what. This looks like it's at the 10% rate, but we don't know exactly what from looking at this decision. Oops. Did that just go away? Oh, let's see. Let's open that up again. I think my screen went away. Here. Let me try to get that up again. Sorry, everyone. Crashed. One second. Okay. Sorry, everyone. Let me get this up here.
Computers always choose Zoom presentations to crap out.
I'm not quite sure how to help you with that.
Or the Alexa.
Okay, here, we're back.
Yay, we can see it.
Okay, so, and then there's a lot of what I would consider kind of unnecessary information, but this talks about the different ways to appeal a decision. You have 1 year to do all of these, which it talks about. And then we get into the narrative section of the decision, which you have to scroll down quite a ways. So again, this talks about, a supplemental claim was filed on August 16th, 2019. So this decision was actually made rather quickly. That's just a few weeks, which is quite remarkable. But based on the fact that they're saying no new evidence was submitted, my guess is it was a hasty decision. So I redacted out the evidence here just for privacy purposes, but the VA is supposed to list the type of evidence that was received and reviewed. And then they can again repeat what the decision was that was made, and they cite the kind of boilerplate information. In this instance, it's referencing a 2019 exam where the examiner said the condition was less likely than not incurred in the service. And then it's talking about pre-existing stressors. I don't know. So they do go into a little bit of detail, but it's not a ton. So if a veteran comes to you, what you're going to want to do is request kind of their whole file from the VA, which you can do. And because without all of this evidence, such as their service treatment records from the 60s, it's going to be hard to sort of put together a complete package to effectively represent them on an appeal. Typically, a veteran will come to you with just a recent rating decision and they'll want your assistance. And the first step that I would usually do is request a complete copy of their file from the VA. Veterans may have that, but they may not. So the first step would be to note the 1-year deadline and then get a copy of their claims file. And what's important for the deadline is, in this world, a veteran can always resubmit an application for benefits. But if you file it within 1 year of a rating decision, you're going to preserve the possible earlier effective date back to the date of this appeal string. So that's why you want to be sure to be mindful of any deadlines associated with this. This is going to be what a board decision looks like. They look a little bit different. So in this decision, entitlement to 70% for PTSD was granted. And then it goes into the decisions, why that decision was made. Again, when you're up at the board, you're working with staff attorneys at the board and ALJs, so they're a bit more detailed and a bit more, I would say, higher quality. But you want to read these carefully and determine if anything needs to be appealed up to the court to get a higher rating, such as 100%, or if the veteran is going to be satisfied with the 70%. And in this context, to get something up to the court, you have 120 days from the date of the decision to appeal to the court, not 1 year. So just be mindful of that. And then the supplemental claim form looks like this. We talked about this some. So typically you're going to be dealing with compensation. The veteran's information goes here. Social and date of birth are important to put on here so the VA can identify the right claimant. Section 2 is usually left blank because this is if the claimant is not the veteran. Typically, you're going to be dealing with the veteran themselves. If the veteran's homeless, you definitely want to indicate that. And homeless in this context doesn't necessarily mean on the street. It could be, couch surfing or something like that. If a client is homeless, the VA will expedite their claim. So that's definitely something you want to note. And here is where you would put the date of the decision notice for the claim or condition that you're going to be appealing. You would put the reason in here. This space is quite limited. So what I often do is in Adobe or in Word, I'll write out a narrative form, what I want to say, and then I'll cut and paste it and lay it on top of this field, just so I'm not limited to the space here provided by this PDF form. And here is where new and relevant evidence needs to be notated. So it can be in the form of any medical care that's provided, or if it's not medical care, you can check other, and you can submit a personal statement. You could submit a newspaper article, a medical treatise, anything like that is going to meet the new and relevant threshold to get the VA to pick up the claim. And then you sign off if you're the representative, or you have the client sign off, and you send it off. So that's the supplemental claim form. The higher level review form is similar. This is the appeal you would file if you don't have any new information to submit, but you want the regional office to take another look at it. So you would put the same information in regarding the client. Check compensation, because typically that's what you would be dealing with. In this context, you can request an informal conference with a ratings agent. I typically don't do this because I don't find the conferences to be that helpful. But if you did want to speak with someone at the VA about your appeal, that is an option you have in the higher level review context. Here, similarly, you would put the date of the decision you're appealing. Again, I would cut and paste a more lengthy narrative on top of the allotted space in Adobe or whatever PDF editor you have, and then you sign off, and that's the higher level review form. The appeal form for the board is even less detailed. There's really no room for argument here. You would just enter in the identifying information for the client, and then you would select which lane you want, direct review, evidence submission, or hearing like we talked about, and then put in here what it is you're appealing and sign off. And this is how you would take something up to the board. where again, unless the veteran is 75 or older, your wait time is going to be measured in years, not months. So I would be very judicious in what you take up to the board. And here too, as with the informal conferences, I don't typically find hearings with the VLJ to be very helpful. Requesting a hearing typically adds years to the wait time. And so unless there's a credibility issue with the client, or I want the client to get in front of a judge to sort of overcome a credibility issue, I typically don't request a hearing and ask for a direct review, meaning the judge will just decide the issue on the record. And no hearing is needed, just because I think the quicker a client can get a decision, the better. Okay, well, that is my presentation. I'm happy to take any questions from anyone. I don't know if any have come in.
We have a question. The question is from Martha Keller. Are homeless veterans poorly served by the VA? Just a small question.
Yeah, I mean, I'm not sure I'm qualified to exactly answer that. I do know that the VA has many programs for homeless veterans to try to get them off the street. I know under the previous administration, Secretary McDonough definitely had a housing first model, which if you're here in San Francisco, you might be familiar with, meaning getting clients, getting veterans into housing and then addressing their many issues. I'm not sure what Secretary Collins' approach is going to be. He is the secretary that was appointed by Trump. I do know that he's testifying tomorrow on the Hill. I don't know if he'll be addressing issues concerning homelessness. So I'm not sure I can talk to the fairness of how the VA treats the VA or the veterans, but important to my practice area is that the VA does expedite claims for veterans that are homeless. And as I mentioned just a few minutes ago, that does not mean necessarily on the street in a tent. It can mean couch surfing. It can be housing that's very vulnerable. If you can substantiate that with a statement from the veteran, the VA will expedite the claim. And when the VA expedites a claim, it does turn years into weeks and sometimes months. And so if you can get money into the veteran quicker, that often will address some of their housing issues. So I'm not sure that answers your question, but I'll leave it at that.
I've got a question from one of our staff attorneys, Stephen Spano. Hello, Stephen. Thank you, John. Very helpful. I believe there was a program to support LGBTQ folks who were discharged dishonorably under previous administrations, but I don't believe the fellowship still exists. Are there programs or advocates that do that work that you know of? And I have to imagine that includes veterans who got a dishonorable status and may not qualify for benefits as a result, trying to have that rectified.
Yes. Hi, Stephen. Great question. So a few things. Issues of discharge, that's kind of on the military DoD side of things. I do know that there was a policy change. I believe it was under the Biden administration, where people could petition the DoD to have their discharge changed for a variety of reasons, but one of them obviously being to be eligible for VA purposes. I unfortunately do not know much about the DoD program. On the VA side of things, I do know that the VA, on that character of discharge process that I talked about at the very beginning, if you encounter a client with unfavorable discharge due to their sexual orientation or their gender identity in the service, that is a way to get a favorable character of discharge determination through the VA. That was a policy change. So the VA will no longer hold that against you, but which might be important. But what may be important to your clients is that if the VA decides a favorable character of discharge determination, that does not change the underlying discharge. That would have to separately be handled through the DoD, which I do not know much about. For resources on that, I know Swords to Plowshares had something going on about that, but that might have sunset. I do know there's a national organization, but I can't remember the name off the top of my head. But if you would like me to get more information, why don't you email me and I can follow up with you.
Excellent. Question from John Paul. You mentioned a presumption of sound health upon entrance to the military. Do medical waivers for entry to the military change this? That's a good question, especially for the global war on terror cohort. In the middle of the 2000s, there were tons and tons of medical waivers. They were trying to bring everybody they could in.
I think that probably would. It has to be clear and unmistakable evidence of a pre-existing condition. So I think if there is a medical waiver and a clear diagnosis of a condition that was not transient, I do think that would overcome the presumption of soundness. I have not personally ever seen that be an issue, but my guess is, yeah, if there was a waiver and clear evidence of a pre-existing diagnosis, I do think that would overcome that. But just know that that's not the end of the sort of analysis. Even if there is a pre-existing condition, if you can show that it was aggravated during service, then it doesn't matter. You can still get it service connected, even if it was pre-existing service.
Question from Anna Page. Do you anticipate veterans who are currently receiving VA benefits to lose their benefits or see a reduction due to the current administration's tactics? It's a good question.
That is a great question, one that we've been getting a lot from our clients with all of Elon Musk's antics and Doge and all that. So, I'm not an expert. Again, Secretary Collins is testifying tomorrow on the Hill, and one of the topics he's expected to testify about are his proposed budget cuts. My sense and the sense of my colleagues in this area is that disability compensation benefits are not going to be reduced or impacted, because that would really take an act of Congress, which isn't going to happen, I think, very easily, because I do think this is one of the rare areas in American politics that is fairly bipartisan in terms of, compensating veterans for their service-connected conditions. But as I mentioned in my presentation, VA's service-connected disability compensation is just one small benefit among a host of benefits provided by the VA. I do think the administration is going to be cutting personnel, especially on the healthcare side of things. And so that will certainly have an impact on the quality of care that veterans are receiving. So I guess to answer your question, I don't think there'll be, black and white cuts, because again, I think that would take something to come through Congress. But I do think there might be staff shortages and other types of cuts that will impact the types of services that veterans receive, but not necessarily the compensation that's received that we talked about mostly in my presentation. So I hope that answers your question. But maybe we'll know tomorrow after his testimony on the Hill.
Constructive cuts and changes in policy within the department. I have a couple of physicians who work within the VA, and they say directives come down every day that are just stupid and counterproductive, as one might imagine. But hopefully, a lot of things are statutory, and it's much more difficult for them to cut if they continue to follow the law. That is, I guess. Does anybody else have any other questions? Oh, somebody said thank you.
Oh, okay. Well, thank you. Yeah. I think my contact information is going to be in the materials. So please feel free to reach out with any questions. I'm happy to offer advice if any of you take on these cases and have any questions.
Awesome. Well, I just sent out the slides and the evaluation link to everybody that registered for the session. We will be, this has been recorded and will be available on ALRP's website. For those who may have missed this session. We will upload it on request to, I think, CLE Hero. They can watch it, and I guess the AI sees that they actually watch the whole session, and then they will print out an MCLE credit for that. But everybody else who's attending, please fill out the evaluation. You'll receive a certificate in the next few days. I'd like to thank John Unruh for the wonderful presentation. It's extremely timely, and I'm thinking maybe in the future we may have more for VA stuff, and may even bring on a physician and get some sort of panel. I think there's a lot of questions on the medical side and the legal side that kind of coincide, like determinations and stuff like that. It seems esoteric, and I know for a fact that veterans, I mean, it's like with any bureaucratic process, it's difficult to wrap your mind around it. They don't tell us anything when we leave. There's no training or anything like that. I, in fact, have passed on your slides to friends over the past couple of years that Doug provided me with. So it's extremely important. Oh, we may have oh, Anna says thank you very much.
Okay.
Okay, well, thank you everybody for attending. Our next MCLE is next week on the 21st or 22nd. It's on SSI benefits, extremely timely as changes are being made. It deals specifically with lifetime changes and how to deal with them. In many cases, determinations may change your income level, age. There's always these changes that need to be addressed. And oftentimes making a change to prevent a lapse of benefits isn't as difficult as people think. So I recommend that everybody attend that if they can. Thank you again, John, and everybody. Let me know if you didn't receive the email link. And if you're interested in joining the panel, please reach out to me. And also, just one last plug, George Takei at our annual reception on October 23rd. The link is in the email, and we look forward to seeing everybody next week. Thank you again so much. Thank you, John.
Okay.